Good morning. Okay, we have everyone here. Mr. Brannick, I understand Mr. Calderavilla is with you.
That's correct, Your Honor. He's at my virtual counsel table here.
Okay, then I will give him a virtual good morning too.
Good morning.
All righty. With that being the case, everyone ready to go. Mr. Norby, did I pronounce that correct, sir?
Nordby, Judge.
Okay. Good thing I'm going to see my eye doctor soon. I need a new prescription here. I just misspelled it. That was my error. Thank you, because I don't want to refer to you improperly today. And did you wish to reserve any time for rebuttal?
I do. I'd like to reserve 5 minutes for rebuttal, please.
Okay. I will do my best to let you know when you get there without unduly interrupting you, sir. With that, counsel, you have the floor and you may proceed.
Thank you very much, Judge, and may it please the court, I'm Daniel Nordby from Schutz & Bowen on behalf of the appellant, Bactus Imaging Solutions, which is now known as ShareCare. I will refer to them as Bactus, though, because that's how they were referred to in the record. Unless the court would prefer otherwise, I'd like to begin today by briefly addressing our second issue in our brief before discussing why Bactus's reproduction costs don't violate the Board of Medicine's rule or the Florida Deceptive and Unfair Trade Practices Act. And that's because the errors we identified in the trial court's consideration of Ms. Weber's summary judgment motion would require reversal irrespective of this court's views on the remaining issues. So the first defect that we identified was the plaintiff's failure to state with particularity the grounds on which the summary judgment motion was based as required by Rule 1.510C. The rule expressly requires a moving party to identify the substantial matters of law to be argued and to specifically identify any evidence upon which the moving party relies. And this court recently held in the Ambrogio decision that it is, quote, reversible error to enter summary judgment on a ground not raised with particularity in the motion for summary judgment. Judged against that standard from this court, the 3-page summary judgment motion here, which is at pages 2803 to 2805 of the record, falls far short of the rule's requirements. Ms. Weber has argued that a general reference to, quote, the pleadings in her summary judgment motion was sufficient to identify the matters of law to be argued with particularity. But that it's in the pleadings defense is exactly what this court rejected in Ambrogio at page 76. And in fact, the only mention of pleadings in Ms. Weber's summary judgment motion is simply part of a quote from Rule 1.510 itself. As in Ambrogio, Rule 1.510's requirement of particularity is not satisfied by generality. And the motion did not state with particularity any legal arguments as to the elements of her claim for unjust enrichment, nor did the motion address any of Bactus's affirmative defenses. Yet the trial judge granted final summary judgment based upon that motion. So for that reason, first, the final judgment must be reversed and remanded for further proceedings. A second and related error was the trial court's determination that Weber carried her summary judgment burden. Ms. Weber unquestionably had the summary judgment burden not only to establish that there were no genuine issues of material fact as to her claim, but to, quote, conclusively refute the factual bases for Bactus's affirmative defenses or to establish that they were legally insufficient. We've cited the Coral Wood Page decision from this court for the very well-established proposition that a moving party cannot carry its burden to refute an affirmative defense when it, quote, wholly fails to address the affirmative defenses. And here again, the operative summary judgment motion at pages 2803 to 2805 of the record does not mention a single one of Bactus's 12 affirmative defenses, much less conclusively refute them. And on appeal, Weber points only to that same word, pleadings, in a quote from Rule 1.510, as though that reference incorporates by reference all of the prior filings or makes legal arguments based on the replies and prior memorandum. Weber also argues that some of the affirmative defenses had been rendered moot or defeated as a matter of law, but those arguments also are nowhere to be found in the 3-page summary judgment motion. And none of the trial court's prior orders to which Weber refers made an explicit conclusion as to the validity of the affirmative defenses. Where a defendant pleads an affirmative defense, and the plaintiff does not negate or deny it by sworn evidence, the plaintiff is not entitled to summary judgment. Moreover, by relying solely on Weber 1, this court's earlier decision on an interlocutory appeal, the summary judgment motion filed below effectively presumed that this court had found a per se violation of FDUPA on the facts, but this court explicitly disclaimed such a filing. Weber therefore had a summary judgment burden to prove not only a deceptive act or unfair practice, but also causation and damages, and the motion failed to do so. Causation is a necessary evidence of a FDUPA claim. The summary judgment motion contained no argument as to causation, and it contained no undisputed summary judgment evidence related to causation. This element involved a disputed issue of fact, essentially whether Bactus's billing practices damaged Weber or whether it was her choice to submit her request in the particular manner that was submitted here. A third and related point on that, and the final point on our issue too, is that the record reflected a genuine issue of material fact as to the amount of damages here. The existence of actual damages, as I just mentioned, is an essential element of a FDUPA claim. The trial court determined that the class's actual damages were approximately $424,000 based on the affidavit of the court-appointed administrator. But that conclusion was not based on undisputed facts. We submitted below an affidavit of William Bailey at pages 3190 to 3196 of the record, which disputed whether the administrator's report included calculations from persons outside the certified class here. Specifically, the class definition in this case only included persons who were billed by the defendant prior to receiving the copies. So billed by the defendant prior to receiving the copies. And that's the class definitions, several places in the record, including at page 437. But the Bailey affidavit pointed to changes in Bactus's billing practices over the course of this litigation that would have made the data set provided to the class administrator over-conclusive. Specifically, the default billing that Bactus engaged in as of March 1st, 2014 and thereafter was that attorneys who requested a patient's records would be billed after or at the same time as receiving the patient's medical records, not billed before receiving the patient's medical records. The undisputed evidence then showed that the requesters after March of 2014 did not fall within the class definition. So any calculation of damages that would have included them would have been over-inclusive. Weber mischaracterizes on appeal and did not refute the Bailey affidavit. The Bailey affidavit took issue with paragraph C of the class definition, billing before receipt of records, not paragraph D of the class definition, which Ms. Weber's counsel has taken issue with here on appeal. The complaint also alleged that records of patients were effectively held hostage pending receipt of payment. Well, the Bailey affidavit also creates a genuine issue of material fact as to that element of the plaintiff's FDUPA claim as to records provided on or after March of 2014. The Bailey affidavit on its face states that it was based on personal knowledge, Mr. Bailey's years of experience with Bactus. It's right there at page 3190 of the record. So if there are no questions on those issues, I'll move on then to the principal merits arguments. And on those arguments, this appeal involves two questions. First, whether charging Ms. Weber's attorney the other entity's rate of $1 per page violated Rule 64B8-10.003, which I'll refer to as the Board of Medicine rule, unless there's another Board of Medicine rule. And the second issue is, if so, whether that constituted an unfair act or practice under FDUPA. Let me briefly address at the outset a defense that was raised in the answer brief, which is an argument that Bactus has waived or abandoned its arguments regarding the proper interpretation of Rule 64B8-10.003. There's no support in the record for this claim, and pages 3 to 6 of our reply brief show how Bactus's trial counsel expressly reserved its right to argue about the trial court's earlier non-final and non-appealable order interpreting the rule. I refer you to Bactus's prior motion for partial summary judgment on FDUPA at pages 1999 to 2012 of the record, which asked the court to decide as a matter of law whether the alleged violation of the rule was a per se violation of FDUPA. In essence, Bactus argued that even if we violated the rule, violation of the Board of Medicine rule does not constitute a violation of FDUPA. That filing did not concede or stipulate that Bactus had in fact violated the rule. Likewise, at the hearing on the plaintiff's motion for permanent injunction, which is in the record, Bactus preserved its right to argue about the interpretation of the rule and whether in fact it had violated it. No cross appeal of the injunction order was either required or authorized because the trial court's ruling on the interpretation of the rule was made in an earlier order granting partial summary judgment on Weber's claim for declaratory relief. Bactus, my client, had no ability to cross appeal because Rule 9.130G only permits cross appeal to review rulings described in subdivisions A3 through A5 of the rule. An order granting partial summary judgment on a claim for declaratory relief is not subject to interlocutory appeal or cross appeal, and therefore those issues are appropriately considered for the first time here on appeal of the final judgment. The question presented to the panel in Weber 1 is also not precluded by the law of the case doctrine. The question presented to the panel of this court in Weber 1 presupposed that charging a patient's attorney the other entity's rate violated the Board of Medicine rule, which was a ruling made by the trial court in that earlier non-appealable, non-final order that I just mentioned. At page 844 of Weber 1, the prior panel therefore explicitly stated that it was confining its analysis to, quote, whether it is a violation of FDUPA for a practitioner to continue to charge the other entity's rate in circumstances where the trial court has found that billing under the rate violates the rule. Weber 1 did not decide what the rule means, and that issue is properly before the court. Weber 1 provided no holding as to the logically prior question of whether the charge by my client in fact violates the Board of Medicine rule, as the trial court found in that earlier non-final order. This panel is therefore not bound by the law of the case doctrine regarding the interpretation of the Board of Medicine rule. And on that question, which is before this court de novo, the text of Rule 64B8-10.003 does not support the trial court's conclusion that Bactus overcharged Weber's attorney for copies of her medical records. The rule identifies 3 categories of parties entitled to request a patient's medical records and the associated amounts that each category of requesters may be charged for reproducing medical records. The categories in the rule are patients, government entities, and a catch-all other entities. Those categories are not defined by the rule or elsewhere, so they should be given their plain and ordinary meaning. A patient is commonly understood to be a person under medical or psychiatric care. We've cited both the Florida statutes and Black's Law Dictionary in support of this common sense definition of what a patient is. The rule requires Bactus to charge a lower rate when medical records are requested by a patient. And the rule specifically mentions the need for continuity of patient care in its justification paragraph. The same rate that applies to patients also applies to requests by a government entity. All other entities entitled to request records, that is, all entities other than patients or governmental entities, can be charged $1 per page under the rule. Bactus applied the plain language of the rule in calculating the reasonable reproduction charges. The request that Bactus received here from Ms. Weber was received from a law firm, not from a patient or a governmental entity. The request is in the record at page 1639. It's a letter from Scott R. Jeeves on letterhead of the Jeeves Law Group, and it requests Ms. Weber's physician to forward reports and office notes to his law office for use in connection with the personal injury lawsuit. To be sure, the letter includes a standard HIPAA consent form signed by Ms. Weber authorizing the release of her records to Mr. Jeeves. But the request received by my client here was not a request by the patient, but by the law firm. The plaintiff's counsel here would read words into the rule as though it said patients, the patient's legal representatives, and government entities must be charged at a lower rate. But principles of statutory construction that also apply to the interpretation of administrative rules counsel to the contrary. The rule uses the term patients, not legal representatives, even though the term legal representatives is defined elsewhere in the Board of Medicine's rules. If the rule here, 64B8-10.003, intended to include legal representatives, it could easily have used the term that is defined elsewhere in the Board of Medicine's rules. It doesn't. It would be contrary to accepted principles of interpretation.
Before you move on, counsel, on the matter of statutory and rule textual analysis, I have a question regarding the rule vis-a-vis the statute. And I want to make sure that I have the right statute and the right rule. If I look at Florida statute 456.057, subparagraph 6, it uses language that is pretty easy to interpret. The text is clear and unambiguous. Shall, upon request of such person or the person's legal representative, furnished in a timely manner. The power to the administrative agency is derivative from the legislative grant. They have no power themselves to promulgate regulations. So when they promulgate this one, can they lessen what the legislature said? Or when we look at that text of subparagraph 2 for patients, should we look to what the legislature said for patients and their representatives and give it the statutory language?
Well, Judge Casanueva, I think the answer to that is you looked at both. You looked at statute and you looked to the Board of Medicine's rule in implementing and interpreting that statute. And there are two portions of the statute that I direct your attention to.
Okay.
The first one is in subsection 6, which you read from, which requires healthcare practitioners to furnish without delay copies of the records to patients and legal representatives. The second provision that is relevant is subsection 17 of the same statute, which refers to specifically what the rule addresses, which is the imposition of the costs for providing those copies. So subsection 6 requires practitioners to provide copies to legal representatives. Subsection 17, which was subsection 18 in an earlier version of the statute, in case you're looking at.
I see it. Thank you very much. I see the section you're referring to.
Okay.
Shall charge no more than the actual cost of copy, etc. Okay, thank you for that. Appreciate it.
You're welcome. And this rule, just to conclude on that point, this rule implements section 17, which is calculation of the reasonable cost.
And I need to tell you that I'm late to the dance because I asked a question, but you have passed 15, and I would like to preserve your 5 minutes since I'm the one who forgot to tell you when you got there.
Well, Judge, if I could just take 1 or 2 more minutes and I'll take that
Your
out
call.
of the rebuttal time. Thank you.
Okay.
Judge, the last point I'd make before I yield my time for rebuttal is that even assuming the trial court correctly interpreted the Board of Medicine rule, Bactus did not violate FDUPA by charging the other entity's rate. I acknowledge on that point that Weber 1 is the law of the case on the application of FDUPA, but we referred in our briefs to circumstances under which a subsequent panel can recede from a prior panel precedent on that point. And we've argued that that standard is satisfied here because the court's prior decision applied an incorrect test in evaluating FDUPA. We pointed to a 3rd district opinion that pointed out subsequent changes to the Federal Trade Commission's definition of unfair practices, and the Florida statute requires courts to give due consideration and great weight to analogous federal law. So the proper interpretation we would submit is the one that the 3rd district in the Porsche Cars decision applied. So to the extent that this court needs to get there, we'd ask the court to recede from the prior panel opinion on that point. Unless there are questions, I'd prefer to save the rest of my time for rebuttal. Thank you.
On that point, I had one question, maybe 2. Does this panel have the authority to overturn its own holding back on Weber 1? And if it does, would it require a complete en banc proceeding?
Thank you for the question, Judge Case. This panel does have the authority to recede from its prior holding in Weber 1, and the standard that's applied there is if there's a manifest injustice. We've argued that that standard is satisfied here. That's the standard for law of the case, receding from something that would otherwise be law of the case. If the question is whether this panel has the authority to recede from prior 2nd DCA precedent in another case, I would agree in those circumstances it would require either en banc consideration by the entire 2nd district to recede from prior 2nd district precedent, or to the extent that there's a conflict with another district court of appeal, such as the 3rd or the 1st, or a conflict with a Florida Supreme Court opinion, then perhaps a certified conflict or a certified question of great public importance would be the appropriate way to tee that up if the en banc court decided that it were not interested in doing so.
All right, thank you.
Thank you.
I have completed my technological skill set here, cleared the timer. So Mr. Brennick, you will start off with no time used up rather than what was previously showing. And with that, counsel, you may proceed.
Thank you, Judge Casanueva. Good morning, Your Honors. May it please the court. I'm Steve Brannick of Brannick, Humphreys, and Berman, representing the Weber class, the appellees in this case. They have worked awfully hard to suggest that this case is very complicated, but at the end of the day, it really couldn't be more simple. First, it couldn't be more simple because this court in Weber 1 has already addressed the merits of the interpretation of the Board of Medicine rule. They argue to this court that Weber 1 didn't include the merits, and that's just not true at all. And let me explain how this went down. In the trial court, first, we moved for summary judgment on the interpretation of the rule, and we won. The trial judge ruled for us and said that the lower patient rate applies. Then with that victory in hand, we moved to step 2, and we asked the court to enter an injunction under FDUPTA. In responding to that, obviously they didn't re-argue the merits in front of the court that they'd already lost in front of. They focused on the FDUPTA argument, and they won the FDUPTA argument so that we ended up as the appellant in Weber 1. So we argued in Weber 1 that we were entitled to an injunction. That's what Rule 9.130 permits. It says that any order granting or denying an injunction gets to go up. At that point, everything relating to the injunction is fair game for them. They can argue that an injunction shouldn't be entered because they didn't violate the rule. And they can argue that an injunction shouldn't be entered because they didn't violate FDUPTA. And in fact, they made both arguments. If you look to their briefs, and their briefs are in the record, they argued the merits of the Board of Medicine rule all throughout their briefs. We cited the pages of their arguments in our brief, but you'll see sprinkled throughout their entire case. They argued in Weber 1 that they did not violate the rule. We, of course, responded by arguing that they had, in fact, violated the rule. And this court agreed with us. This court ruled. If you look at this court's opinion is in the record at page 2726. And what this court said, and this is in the text of the opinion, when the request is made by the lawyer on behalf of the patient, it's the same as if the patient had requested the records so that the lower patient rate applies. Then there's footnote 4 of the opinion also at record 2726 where the court explains itself. So this court in Weber 1 ruled on the merits. Now they say, well, that was dicta because that really wasn't in front of the court. And that's just not true. And how do we know that? Because this court's holding was that the trial court was wrong not to enter the injunction. The only way you can reach that holding is by holding, number 1, that they violated the rule, and number 2, they violated FDUPTA. So the holding makes clear that the Weber 1 ruled both on the merits of the interpretation of the rule and on the FDUPTA claim. And on the merits, there is nothing complicated about this rule. What the rule says, and there's really nothing much I can add to what this court already said in Weber 1, but what the rule says is when the patients are, quote, when the records are, quote, for the patient, close quote, then the lower patient rate applies. It's not who requests the record, it's who the records are for. So when the attorney requests the records for the benefit of the patient, if the lower rate applies, it doesn't matter whether it's the patient's mom or dad or aunt or uncle or nephew or niece or agent or attorney. As long as those records are requested for the patient, then the lower patient rate applies. It's as simple as that. And every single court to look at this issue has ruled that way. Going back to 2011, we've got a trial court decision in Orange County that rules our way. Then we've got in the Allen case, the very comprehensive opinion by Judge Levins, which was affirmed per curiam by this court in the Allen case. And then, of course, we have the order below in Weber 1 and this court's ruling in Weber 1. This issue has been settled and there's absolutely no good reason to revisit. As to The Fidupta claim, Mr. Nordby admits that they are taking a second swing at the same pitch that they swung and missed on in Fidupta in Weber 1. This court clearly rejected their argument on Fidupta. Now, Mr. Nordby says, well, the court applied the wrong standard. The court applied the standard that Mr. Nordby's client asked them to apply. The court was presented in their briefs the suggestion that the PNR, the Beacon Hill case, a Florida Supreme Court case, set the standard for what unfair means. We agreed. We also cited the PNR, the Beacon Hill case. And then that's what this court relied on as well. So there was agreement in the trial court, in the appellate court in Weber 1 as to what the standard of unfairness was. The cases that they argue now, that they suggest somehow change the standard, were not argued at all in their briefs in Weber 1. They didn't raise that argument until rehearing. And of course, it was improper at that point to raise that new argument. And so this court denied rehearing. They then took this argument that there was somehow a new standard to the Florida Supreme Court, and the Florida Supreme Court denied review. So the Fidupta issue is settled. This court was correct, and there's certainly no manifest injustice that would suggest that this court should revisit that ruling. And I think they are stretching a little bit when they argue that this court has the right, without going in bank, to change that previous ruling. I would agree that when an appellate court decides a case-specific issue, and then addresses that same case-specific issue in a second case, there may be circumstances where it can reassess what it decided on that case-specific issue. The opinion in Weber 1 was not a case-specific issue. The opinion in Weber 1 was a broad decision that defined what that rule meant and defined what unfair meant under Fidupta. That's a ruling that, of course, impacts people statewide. And I don't think that this court can, under the guise of some manifest injustice, just change its mind without going in bank. So now, let me go to their summary judgment argument, because I think that they're even weaker here. Their complaint is that our motion for summary judgment was too short and too conclusory. Well, of course it was short. At that point in time, we had already won on the merits of the interpretation of the rule, both in the trial court and in this court, and we'd already run on the merits of the Fidupta case. The only thing left to do was to determine what were the damages that were suffered by the plaintiff class as a result of the violation. And it wasn't rocket science to figure out what the damages were. The question was, it's a matter of multiplying 75 cents times the number of copies. And that's exactly what we showed. We had the class administrator who, based on the records that were provided by Bactus, showing the number of copies that were overcharged, took the number of copies overcharged, multiplied by 75 cents, and came up with a 470,000 damage figure here. There is nothing complicated about that. And remember, Bactus was ordered to provide those numbers by the trial court, and the numbers that they were ordered to provide were the number of records that were requested and paid for by the plaintiff class. So they make this argument that we didn't address their affirmative defenses. Well, of course we did. We cited to our reply that had a very, very extensive discussion of their affirmative defenses, but they overstate what the cases say. The cases state that you have an obligation to refute legally sufficient affirmative defenses. They had no legally sufficient affirmative defenses. They got a chance to argue anything they wanted in front of the trial court, and the trial court found that none of their defenses were legally sufficient. So we certainly satisfied our burden on summary judgment. They then argue that this affidavit of Mr. Bailey created some sort of issue of fact. All that Mr. Bailey said was that as of March 1st, 2014, Bactus changed its policy and stopped demanding payment first before providing the records. But they still demanded payment. And the class includes only those people who actually paid for those overcharges. And Backus was specifically ordered to produce the records showing the records requested that were in fact paid. Now, what Mr. Bailey's affidavit doesn't say is he doesn't say that the number that was calculated by our administrator was wrong. He doesn't say that change in policy on March 1st, 2014 impacted those numbers in any respect. And of course he couldn't, because we all know now that he actually had left the company back in January of 2014. So he wasn't competent to testify about anything. He certainly wasn't competent to testify about the change in the rule on March, in the change of their internal practice on March 1st, 2014. And clearly he couldn't testify about whether there was something wrong with our damage calculation. These were all based on Backus's records. If they thought that our calculation was wrong, they could have gotten an affidavit from anybody in their organization to say, here's how the class administrator screwed up in his calculation of the damages. They didn't do that. They did not present an affidavit. They did not create an issue of material fact. So the case is simple. It was resolved by Weber 1, and there's nothing complicated about the damages in this case. So for all of those reasons, we think that the judgment below should be affirmed.
Thank you, Mr. Brannick. Okay. We stop the clock. Counsel, in light of your decision to go on, you required me to use latent mathematical skills. I've done my best and I've erred on your side. So you have 2.5 minutes remaining.
Thank you, Judge. Just a few brief points in rebuttal then. The first is that the language of the Board of Medicine rule does not say that the lower charge applies to records that are requested for, quote, requested for the patient, as Mr. Brannick suggested. Requested by the patient is not what the rule says. It says for patients and governmental entities, the reasonable costs of reproducing copies of written or typed documents or reports shall not be more than the following. So the rule simply doesn't say what my friend on the other side suggests that it says. And I think that difference is meaningful in a proper interpretation of what the rule says. Second, on the law of the case issue, opposing counsel suggested that the manifest injustice standard that is in this court's case law and in the Florida Supreme Court's case law only applies to, quote, case-specific issues. I don't see that standard in the precedent. And in fact, the case that we cited on that manifest injustice standard, the White Sands case from this court, which Weber acknowledges the standard that applies, is an example of where a subsequent panel of this court receded from a prior panel's legal conclusions to avoid a manifest injustice. And that's exactly what we're suggesting. If this court needs to reach that issue, that it do here. For all the reasons I'd said earlier, we don't think the court needs to reach the issue of the prior panel precedent for either the discussion of the summary judgment motion or for the interpretation of the rule. But if the panel needs to get there, that's the standard that applies. The summary judgment motion, again, 2803 to 2805 of the record, doesn't cite to the replies to the affirmative defenses. It doesn't mention them. It doesn't mention the affirmative defenses. The cross-reference that the plaintiff has concocted here is a reference to the word pleadings in the summary judgment motion. And the word pleadings is included in a quote from the summary judgment rule. If this plaintiff's summary judgment motion mentioned or incorporated by reference their prior replies and identified with particularity what arguments they intended to advance in favor of their summary judgment motion, such a motion would arguably satisfy Rule 1.510. That's not what this motion does. And in this court's Ambrogio decision, which is the one I would urge you to look at, it's the one we cited in our briefs, the issue there was a summary judgment motion that didn't mention an affirmative defense of a statute of limitations. And the parties appeared to argue in front of this court, well, it's very easy to calculate what the statute of limitations was based on the record. But the summary judgment motion didn't talk about the statute of limitations defense, and this court reversed based on Rule 1.510's particularity requirement.
Thank
That's
you,
the
counsel. I
same
think
thing
you
we should
have
argue here.
gone past the time I wanted you to finish that argument. I think we have the case relatively in hand. I thank you for your presentation. Hope you all stay well. If the panel will stay with me for a moment, I have a time matter to discuss with them. Let's see, we're going to take a short recess. Be back at 11:40 a.m. Thank you
Thank
all.
Judge.